This is part 48 as far as our series of lectures is concerned. In this part, we shall be dealing with chapter 32, dealing with execution, suspension, remission and commutation of sentences. And then the first part of this chapter deals with execution, and right from section 413 up to section 416 deals with execution of death sentence. And section 413 says execution of order passed under section 368, and it says, when in a case submitted to the High Court for the confirmation of a sentence of death, the Court of Session receives the order of confirmation or other order of the High Court thereon, it shall cause such order to be carried into effect by issuing a warrant or taking such other steps as may be necessary. Now, death sentence is subject to confirmation by the High Court with which you are dealt, right from section 366 up to section 371 of the Criminal Procedure Code during course of our lecture. Now, with this next section, section 414 deals with execution of sentence of death passed by High Court, and it says, when a sentence of death is passed by High Court in appeal or in revision, the Court of Session shall, on receiving the order of the High Court, cause the sentence to be carried into effect by passing a warrant. Section 415 says, postponement of execution of sentence of death in case of appeal to Supreme Court. And it says, where a person is sentenced to death by High Court and an appeal from its judgment lies to Supreme Court under subclause A of subclause B of clause 1 of our Article 134 of the Constitution, the High Court shall order the execution of the sentence to be postponed until the period allowed for preferring such appeal has expired, or if an appeal is preferred within that period until such appeal is disposed of. Subclause 2 says, where a sentence of death is passed or confirmed by the High Court and the person sentenced makes an application to the High Court for the grant of certificate under Article 132 or under subclause C of clause 1 of Article 134 of the Constitution, the High Court shall order the execution of the sentence to be postponed until such application is disposed of by High Court, or if a certificate is granted on such application until the period allowed for preferring an appeal to the Supreme Court on such certificate is expired. Subclause 3 says, where a sentence of death is passed or confirmed by High Court and the High Court is satisfied that the person sentenced intends to present a petition to the Supreme Court for grant of special leave to appeal under Article 136 of the Constitution, the High Court shall order the execution of the sentence to be postponed for such period as it considers sufficient to enable him to present such petition. And section 416 says, postponement of capital sentence on pregnant woman, and says, if a woman sentenced to death is found to be pregnant, the High Court shall commute the sentence to imprisonment for life as per section 416. Now, this is also the time for me to remind you that during course of time, as and when we deal with the provisions of the Criminal Procedure Code, do have reference to the second schedule of the Criminal Procedure Code, which deals with various forms. Now, to understand the chapter with which we are dealing, if you start reading right from form number 41, namely form number 41, form number 42, form number 43, form number 44 and 44A, that will serve the purpose from the point of view of understanding and have clarity regarding the topic with which we are dealing. Now, right from section 417 up to section 420 is the part which deals with execution of sentence, namely the sentence when it is of imprisonment. 417 says, power to appoint place of imprisonment. And it says, subclause 1, except where otherwise provided by any law for the timing in force, the state government may direct in what place any person liable to be imprisoned or committed to custody under this code shall be confined. Subclause 2 says, if any person liable to be imprisoned or committed to custody under this code is in confinement in a civil jail, the court or magistrate ordering the imprisonment or committal may direct that the person be removed to a criminal jail. Subclause 3 says, when a person is removed to a criminal jail under subsection 2, he shall on being released therefrom be sent back to civil jail unless either 3 years have elapsed since he was removed to criminal jail, in which case he shall be deemed to have been released from the civil jail under section 58 of the Code of Civil Procedure 1908 or section 23 of the Provincial Insolvency Act 1920, as the case may be. Or the court which ordered him imprisonment in the civil jail has certified to the officer in charge of the criminal jail that he is entitled to be released under section 58 of the Code of Civil Procedure 1908 or under section 23 of the Provincial Insolvency Act 1920, as the case may be. Now, execution of sentence of imprisonment is dealt as far as section 418 is concerned, where it says, where the accused is sentenced to imprisonment for life or to imprisonment for term in cases other than those provided by section 413, the court passing the sentence shall forthwith forward a warrant to the jail or other place in which he is or is to be confined, and unless the accused is already confined in such jail or other place, shall forward him to such jail or other place with the warrant, provided that where the accused is sentenced to imprisonment till the rising of the court, it shall not be necessary to prepare or forward a warrant to jail, and the accused may be confined in such place as the court may direct. Subclause 2 says, where the accused is not present in a court when he is sentenced to such imprisonment as is mentioned in subsection 1, the court shall issue a warrant for his arrest for the purpose of forwarding him to the jail or other place in which he is to be confined, and in such a case the sentence shall commence on the date of his arrest. Section 419 deals with direction of warrant for execution, and it says, every warrant for the execution of a sentence of imprisonment shall be directed to the officer in charge of the jail or other place in which the prisoner is or is to be confined. And lastly, section 420 says, warrant with whom to be lodged, and it says, when the prisoner is to be confined in a jail, the warrant shall be lodged with the jailer. So that is as far as imprisonment is, execution of sentence, namely imprisonment, is concerned. With this, now as when the sentence is that of fine, we start dealing right from section 421, and it says warrant for levy of fine. And subclause 1 says, when an offender has been sentenced to pay a fine, the court passing the sentence may take action for the recovery of the fine in either or both of the following ways, that is to say, it may a. issue a warrant for the levy of amount by attachment and sale of any movable property belonging to the offender. B. Issue a warrant to the collector of the district authorizing him to realize the amount as arrears of land revenue from the movable or immovable property or both of the defaulter, provided that if the sentence directs that in default of payment of fine, the offender shall be imprisoned, and if such offender has undergone the whole of such imprisonment in default, no court shall issue such warrant unless for special reasons to be recorded in writing it considers it necessary so to do, or unless it has made an order for the payment of expenses or compensation out of the fine under section 357. Subclause 2 says, the state government may make rules regulating the manner in which warrant under clause small a of subsection 1 are to be executed, and for the summary determination of any claims made by any person other than the offender in respect of any property attached in execution of such warrant. Subclause 3 says, where the court issues a warrant to the collector under clause B of subsection 1, the collector shall realize the amount in accordance with the law relating to recovery of arrears of land revenue as if such warrant were certificate issued under such law, provided that no such warrant shall be executed by the arrest or detention in prisons of the offender. Effect of such warrant is dealt as far as section 422 is concerned, which says a warrant issued under clause small a of subsection 1 of section 421 by any court may be executed within the local jurisdiction of such court, and it shall authorize the attachment and sale of any such property outside such jurisdiction when it is endorsed by district magistrate within whose local jurisdiction such property is found. Section 423 deals with warrant for levy of fine issued by a court in any territory to which this court does not extend. And it says, notwithstanding anything contained in this code or any other law for the time being in force, when the offender has been sentenced to pay a fine by criminal court in any territory to which this code does not extend, and the court passing the sentence issues a warrant to the collector of a district in the territory to which the code extends, authorizing him to realize the amount as if it were an arrear of land revenue, such warrant shall be deemed to be a warrant issued under clause small b of subsection 1 of section 421 by a court in the territories to which this code extends, and the provision of subsection 3 of the said section as to the execution of such warrant shall apply accordingly. Section 424 deals with suspension of execution of sentence of imprisonment, and subclause says, when an offender has been sentenced to fine only and to imprisonment in default of payment of fine, and the fine is not paid forthwith, the court may order that the fine shall be payable either in full or before a date not more than 30 days from the date of the order, or in 2 or 3 installments, of which the first shall be payable on or before a date not more than 30 days from the date of the order, and the other or others at an interval or intervals as the case may be of not more than 30 days. Suspend the execution of the sentence of imprisonment and release the offender on the execution by the offender of the bond with or without sureties as the court thinks fit, condition for his appearance before the court on the date or dates on or before which payment of fine or installment thereof as the case may be is to be paid, and if the amount of fine or any installment as the case may be is not realized on or before the latest date on which it is payable under the order, the court may direct the sentence of imprisonment to be carried into execution at once. Subclause 2 says, the provisions of subsection 1 shall be applicable also in any case in which an order for the payment of money has been made, on non-recovery of which imprisonment may be awarded, and the money is not paid forthwith, and if the person against whom the order has been made, on being required to enter into a bond such as is referred to in that subsection, fails to do so, the court may at once pass sentence of imprisonment. Now, the next part as far as this chapter is concerned, right from section 425 up to 431, deals with general provisions regarding execution, and 425 deals with who may issue warrant, and then it says every warrant for the execution of a sentence may be issued either by a judge or magistrate who passed the sentence or by his successor in office. Section 426 deals with sentence on escape convict when to be taken effect, and subclause 1 says when a sentence of death, imprisonment for life or fine is passed under this code or on an escape convict, such sentence shall, subject to the provision herein before contained, take effect immediately. Subclause 2 says when a sentence of imprisonment for a term is passed under this code on an escape convict, if such sentence is severe in kind than the sentence which the convict was undergoing when he escaped, the new sentence shall take effect immediately. If such sentence is not severe in kind than the sentence which such convict was undergoing when he escaped, the new sentence shall take effect after he has suffered imprisonment for a further period equal to that which at the time of his escape remained unexpired of his former sentence. Subclause 3 says, for the purposes of subsection 2, a sentence of rigorous imprisonment shall be deemed to be severer in kind than a sentence of simple imprisonment. 427 says, sentence on offender already sentenced for another offense. And it says, when a person already undergoing a sentence of imprisonment is sentenced on subsequent conviction to imprisonment or imprisonment for life, such imprisonment or imprisonment for life shall commence at the expiration of the imprisonment to which he has been previously sentenced, unless the court directs the subsequent sentence shall run concurrently with such previous sentence, provided that where a person who has been sentenced to imprisonment by an order under section 122 in default of furnishing security is, with such undergoing such sentence sentenced to imprisonment for an offence committed prior to the making of such order, the latter sentence shall commence immediately. Subclause 2 says, when a person already undergoing a sentence of imprisonment for life is sentenced on subsequent conviction to imprisonment for a term or imprisonment for life, the subsequent sentence shall run concurrently with such previous sentence. Section 428 says, period of detention undergone by the accused to be set off against the sentence of imprisonment. And it says, when an accused person has, on conviction, be sentenced to imprisonment for a term, not being imprisonment in default of payment of fine, the period of detention, if any, undergone by him during the investigation, inquiry or trial of the same case and before the date of such conviction shall be set off against the term of imprisonment imposed on him on such conviction, and the liability of such person to undergo imprisonment on such conviction shall be restricted to the remainder, if any, of the term of imprisonment imposed on him, provided that in cases referred to in section 433 capital A, such period of detention shall be set off against the period of 14 years referred to in that section. 429 is a saving clause which says, nothing in section 426 or section 427 shall be held to excuse any person from any part of the punishment to which he is liable upon his former or subsequent conviction. Subclause 2 says, where an award of imprisonment in default of payment of fine is annexed to a substantive sentence of imprisonment, and the person undergoing the sentence is after its execution to undergo a further substantive sentence or further substantive sentences of imprisonment, effect shall not be given to the award of imprisonment in default of payment of the fine until the person has undergone the further sentence or sentences. Section 430 deals with return of warrant on execution of sentence, and it says, when a sentence has been fully executed, the officer executing it shall return the warrant to the court from which it is issued with an endorsement under his hand certifying the manner in which the sentence has been executed. Section 431 deals with money ordered to be paid recoverable as fine, and it says any money other than a fine payable by virtue of any order made under this code, and the method of recovery of which is not otherwise expressly provided for shall be recoverable as if it were a fine, provided that section 421 shall, in its application to an order under section 359 by virtue of this section, be construed as if the proviso to subsection 1 of section 421 after the words of the figure under section 357 the words and figures or an order for payment of cost under section 359 have been inserted. With this now, the last part as far as this chapter is concerned deals with suspension, remission and commutation of sentences, for which we have to refer to right from section 432 up to section 435 of the Criminal Procedure Code. 432 deals with power to suspend or remit sentences. Subclause 1 says, when any person has been sentenced to imprisonment for an offence, the appropriate government may at any time, without conditions or upon any condition which the person sentenced accepts, suspend the execution of his sentence or remit the whole or any part of the punishment to which he has been sentenced. Subclause 2 says, whenever an application is made to the appropriate government for the suspension or remission of a sentence, the appropriate government may require the presiding judge of the court before or by which the conviction was had or confirmed to state his opinion as to whether the application should be granted or refused, together with his reasons for such opinion, and also forward with the statement of such opinion a certified copy of the record of the trial or of such record thereof as exists. Subclause 2 says, if any condition on which a sentence has been suspended or remitted is, in the opinion of the appropriate government, not fulfilled, the appropriate government may cancel the suspension or remission, and thereupon the person in whose favor the sentence has been suspended or remitted may, if at large, be arrested by any police officer without warrant and remanded to undergo an unexpired portion of the sentence. Subclause 4 says, the condition on which the sentence is suspended or remitted under this section may be one to be fulfilled by the person in whose favor the sentence is suspended or remitted, or one independent of his will. Subclause 5 says, the appropriate government may, by general rule or special order, give directions as to the suspension of sentences and the condition on which petition should be presented and dealt with, provided that in the case of any sentence other than a sentence of fine passed on a male person above the age of 18 years, no such petition by the person sentenced or by any other person on his behalf shall be entertained unless the person sentenced is in jail, and where such petition is made by a person sentenced, it is presented through the officer in charge of the jail, or where such petition is made by any other person, it contains a declaration that the person sentenced is in jail. Subclause 6 says, the provisions of the above subsection shall also apply to any order passed by criminal code under any section of this code or of any other law which restricts the liberty of any person or imposes any liability upon him or his property. Subclause 7 says, in this section and section 433, the expression appropriate government means the cases where the sentence is for the offence against or order referred to in subsection 6 is passed under any law relating to matter in which the executive power of the Union extends the central government. In other cases, the government of the state within which the offender is sentenced or the said order is passed. Section 433 deals with power to commit sentence, and it says the appropriate government may, without the consent of the person sentenced, commit a sentence of death for any other punishment provided by the Indian Penal Code, a sentence of imprisonment for life for imprisonment for a term not exceeding 14 years or fine, a sentence of rigorous imprisonment for simple imprisonment for a term to which that person might have been sentenced or for a fine, a sentence of simple imprisonment for fine. Section 433A deals with restriction on powers of remission or commutation in certain cases, and it says, notwithstanding anything contained in section 432, where a sentence of imprisonment for life is imposed on conviction of a person for an offence for which death is one of the punishment provided by law, or where a sentence of death imposed on a person has been computed under section 433 into one of imprisonment for life, such person shall not be released from prison unless he has served at least 14 years imprisonment. Section 434 deals with concurrent power of central government in case of death sentences, and it says the powers conferred by section 432 and 433 upon the state government may, in the case of sentences of death, also be executed by central government. The last section 435 states state government to act after consultation with central government in certain cases, and it says the powers conferred by section 432 and section 433 upon the state government to remit or commute a sentence in any case where the sentence is for an offence which was investigated by the Delhi Special Police Establishment constituted under the Delhi Special Police Establishment Act of 1946, or by any other agency empowered to make investigation into an offence under any central act other than this code, or which involved the misappropriation or destruction of or damage to any property belonging to the central government, or which was committed by a person in the service of the central government while acting or purporting to act in the discharge of his official duty, shall not be exercised by the state government except after consultation with the central government. Subclause 2 says, no order of suspension, remission or commutation of a sentences passed by the state government in relation to a person who has been convicted of offences, some of which relate to matters to which the executive power of the Union extends, and who has been sentenced to separate terms of imprisonment which are to run concurrently, shall have effect unless an order for the suspension, remission or commutation, as the case may be, of such sentence has also been made by the central government in relation to the offences committed by such person with regard to matters to which the executive power of the Union extends. So this is regarding execution, suspension, remission and commutation of sentences with which you are dealt, right from section 413 up to section 435 of the Criminal Procedure Code.